Welcome to this video for sellers of immovable property. If you are watching this video, you have most probably decided to sell a property. Before we continue with this informative video, give us the opportunity to introduce ourselves. MC van der Berg Incorporated is a well-established legal practice specializing in property law. Our head office is in Centurion with a satellite office in Pretoria East, and we conduct business in the Greater Pretoria, Centurion, Midrand, Johannesburg and surrounding areas. We have recently also opened offices in Durban and in Cape Town. The conclusion of a deed of sale and the ensuing transfer process can hold inherent risks if you do not obtain timely advice.
The aim of this video is to inform you, the prospective seller, about important matters that you should be aware of before you sign the offer to purchase. Throughout this video, we will be referring to the MC Seller's Guide, which is available on our website. There you will find more information on all the issues discussed today.
If you make use of the services of an estate agent, you should make sure that they are accredited by the Estate Agency Affairs Board. An estate agent should be able to show you his or her Fidelity Fund certificate as proof. Nowadays, estate agents are qualified professionals. You can expect the estate agent who markets your property to be effective and professional. However, please bear in mind that the commission that an estate agent earns on a transaction is his or her financial remuneration. This is an incentive to find prospective buyers and introduce the right buyers to your property in order to sell it at the right price as quickly as possible. There are various mandates that can be agreed on with the estate agent. Sole mandate, exclusive mandate, multi-listing mandate, open mandate. Make sure you know what type of mandate you agreed on and what your duties and rights and those of the agent are in this regard. As the seller, you are liable to the agency if they are the effective cause of the transaction. You should therefore make sure that any prospective private buyer did not initially view your property through an estate agent. Also make sure that any prospective buyer that makes an offer through Agency A has not viewed your property earlier through Agency B. This could cost you dearly in the end. The Consumer Protection Act is often incorrectly interpreted, and this can lead to misconceptions. For example, it is not correct that the Act is applicable to all property transactions. Sellers are often brought under the wrong impression that the said Act is applicable to their transaction, and subsequently that the purchasers have certain legal rights in terms of the Act, which they actually don't have. Furthermore, that the sellers are obliged to waive certain common law protection measures such as the Voetstoots clause. This mistake can cost the seller dearly. The offer to purchase that the purchaser makes becomes the deed of sale when you, the seller, accepts it in writing. It is therefore of the utmost importance that you take note of certain matters and obtain legal advice before you accept the offer. Once you have signed the contract, you are bound to the provisions thereof. Should you decide to appoint us to deal with the transfer of your property, we offer you, the seller, a free consultation so that you can discuss the offer to purchase with us before you accept it. Remember, prevention is better than cure. In a typical transaction involving the transfer of a property, there are usually 3 registration actions that have to take place simultaneously at the deeds office. The transfer of the property, the registration of the purchaser's bond, the cancellation of the seller's bond. As the seller, you are involved with a transferring attorney and, if a bond is registered on the property, also the bond cancellation attorney. Let me explain the role and importance of the transferring attorney. The transferring attorney is the firm of attorneys that is responsible for the transfer of the property into your name at the deeds office. The transferring attorney must see to it that the conditions of the deed of sale is complied with by both the purchaser and the seller. Draft all the legal documents and see that it is signed. Ensure that the purchase price is secured. See to all the other financial aspects of your transaction. coordinate with the lodging and registration of the documents at the deeds office with the other attorney firms, reconcile the finances, and provide you with a final settlement account. Your risk, your right. Your choice in appointing the transferring attorney. MC van der Berg Incorporated. As the seller, it is your right to appoint the firm of transferring attorneys that will deal with the transfer of your property. You should use a transferring attorney that is knowledgeable and capable to look after your interests by giving you the necessary advice and guidance. They should enforce the agreement and transfer your property expeditiously. Should you decide to nominate us, MC van der Berg Incorporated, we'll gladly assist you in the transfer of your property. Despite the fact that the seller nominates the transferring attorney, the purchaser is responsible for the payment of the transferring attorney's fees and expenses. The seller is only responsible for the costs involved in the cancellation of his or her bond. If there is an outstanding bond on your property, we will pay the bond off at your bank from the proceeds of the transaction, and thereafter cancel the bond at the deeds office. In terms of the National Credit Act, banks are entitled to levy penalty interest if they are not given 90 days written notice of the proposed cancellation of a bond. You can inform us by email at bc@mcvdberg.co.za of your intention to sell your property, whereupon we will see to it that the proper notice is given to the bank in order to ensure that you are not responsible for penalty interest. You may be liable to pay capital gains tax when you sell your property. Capital gains tax is payable to SARS at the end of the fiscal year in which the property was sold. We will be able to advise you on the capital gains tax implications brought about by the sale of your property. We must obtain a clearance certificate from the City Council and show it to the deeds office to prove that your City Council account has been paid in advance. Closing the rates and taxes and utilities accounts at the City Council and the subsequent reimbursements can be problematic. You can be assured that we will give you the necessary guidance in this regard. We are also obliged to hand in a clearance certificate for the sectional title body corporate and/or the Home Owners Association as proof that this account has been paid in advance. We therefore see to the closing of these accounts on your behalf. We are required by law to see to it that you, the seller, provide us with certain certificates. These certificates include the following: electrical certificate, electric fence certificate, if applicable, and gas certificate, if applicable. In the case of older houses in particular, repair work is sometimes needed before these certificates can be issued. In order to ensure that your transaction is not delayed, you should make arrangements immediately to obtain these certificates. The costs relating to obtaining these certificates, as well as any potential repairs, have to be paid by you, the seller. To date, there is no legal requirement that the building plans for a specific property have to be in order before we can transfer the property. The purchaser, who eventually makes an offer on your property, can however add a condition in the deed of sale which states that he or she should be supplied with the approved plans. The banks are also more inclined to make the registration of the purchaser's bond subject to the delivery of approved plans. You should not simply accept that the building plans are in order. Make sure that the swimming pool, Wendy house, carports and boundary walls are all indicated on the building plans. In the case of sectional title units, it can be even more problematic, as both building plans and sectional title plans must be approved. If it is your intention to purchase a new property, you should make the deed of sale subject to the successful sale and registration of your current property. You are welcome to make an appointment with us before you sign a new contract, so that we can advise you on coordinating the timelines. we suggest that you include a detailed list or an addendum in the deed of sale in which you specify which items are fittings that you will be removing, as well as which items are fixtures and thus form part of the property. You should guard against giving the purchaser occupation if you are not comfortable doing so and are not contractually protected. If you have agreed in the deed of sale to give the purchaser occupation on a specific date, you are contractually and legally bound to that date. If the transaction should be cancelled, it can be an expensive, difficult and time-consuming process evicting people from a property. Depending on the financial circumstances of the purchaser, it should not take longer than a month to obtain a bond. However, there may be reasons why the purchaser needs more time for this, and you should use your discretion in this regard. The purchaser or purchaser's bank often sets the condition that he or she must sell and register their current property before the new bond can be registered. You pay for this transaction. This can present you with a dilemma. You do not want to refuse the offer, but you also do not want to take your property off the market for an indefinite period. There are legal constructions that can protect you, should an offer be made to you subject to the sale of the purchaser's property. We will gladly advise you on the correct wording of such clauses in the deed of sale. FICA is an acronym for the Financial Intelligence Center Act. This act requires the nominated persons and institutions that are involved in your transaction to verify certain information and keep a record of it. FICA also requires attorney firms to report suspicious transactions, such as when large amounts of cash changes hands, to the FIC or Financial Intelligence Center. You should under no circumstances become involved in a transaction in which cash is paid under the table. Why MC van der Berg Incorporated? Your expectation is our mission. As mentioned earlier, as the seller, you are entitled to appoint the transferring attorney who has to look after your interests.
We are a dynamic and positive team that believe that all people matter. The MC van der Berg team is ready to assist you and to look after your interests.
Visit us at www.mcvdberg.co.za and read our MC Seller's Guide. It is packed with useful information. You can also call us at 012-660-6000 or send us an email at info@mcvdberg.co.za.